On July 17, 2026, the U.S. Court of Appeals for the Third Circuit, sitting en banc, meaning the full court, not a three-judge panel, ruled 10-5 that New Jersey's ban on semi-automatic assault firearms and its ban on magazines holding more than 10 rounds both violate the Second Amendment. The opinion is 192 pages long. It is the first time any federal appeals court has ever struck down a state assault weapons ban. And it was written by a judge appointed to the bench in 2022 by President Joe Biden. Now here is what most of the coverage is not telling you. On July 31, 2026, the same day gun stores thought they could finally start selling AR-15s and standard capacity magazines to New Jersey residents, New Jersey filed a motion asking the Third Circuit to stay its own mandate. Filing that motion temporarily paused the issuance of the mandate while the court considers the request. The bans have been ruled unconstitutional. New Jersey gun owners still cannot walk into a store and buy a covered rifle or magazine today. The mandate has not been issued. The stay motion is pending. This video tells you exactly what that means and what has to happen before anything changes on the ground. Let me start with what the Third Circuit actually held, because the legal reasoning matters as much as the outcome, and this opinion is going to be cited in Viramontes versus Cook County when the Supreme Court hears oral argument this fall. The case is Association of New Jersey Rifle and Pistol Clubs versus Attorney General of New Jersey, consolidated with two related challenges. The majority opinion was authored by Circuit Judge Ariana Julia Freeman. She was confirmed to the Third Circuit in 2022. She is not a conservative jurist by any conventional measure. And when she applied the Bruin text and history framework to New Jersey's laws, those laws failed the test. The Bruin analysis runs in two steps. Step 1 asks whether the Second Amendment's plain text covers the conduct being regulated. Step 2 asks whether the government can demonstrate a historical tradition of the specific type of regulation it is imposing. On Step 1, Judge Freeman was direct. The textual analysis for AR-15 bans, she wrote, is straightforward. Even the narrowest founding-era definition of arms, addressed by the Supreme Court in Heller, stated that all firearms constituted arms. Because semi-automatic rifles are firearms, they are arms within the meaning of the Second Amendment. The court applied the same analysis to magazines, holding that magazines are required to operate a firearm and are therefore covered arms within the scope of the Second Amendment's protection. Both the rifles and the magazines clear Step 1. The conduct is presumptively protected. The burden shifts to New Jersey. New Jersey failed Step 2. With more than 24 million AR-15 style rifles and 100 million magazines in circulation, the platform is plainly in common use for lawful purposes by millions of law-abiding Americans. New Jersey produced no founding-era historical analog for banning commonly owned semi-automatic arms. The state's proffered historical analogs were, in the court's words, too late in time, and none enacted an outright ban on a commonly owned arm. Judge Freeman closed the majority opinion with a line your audience needs to hear precisely. Bans on weapons in common use for lawful purposes are unlawful. So are severe restrictions on weapons in common use for lawful purposes. However much nuance we might employ, we could not overcome the dearth of relevantly similar founding-era restrictions. That is Step 2. New Jersey could not meet its burden. The bans fall. Now let me be precise about what this ruling does and does not cover, because the scope of the decision matters for compliance. The ruling struck down New Jersey's assault firearms ban and its magazine ban. It addressed the specific New Jersey statutes. The Third Circuit covers New Jersey, Pennsylvania, Delaware, and the U.S. Virgin Islands. The decision does not automatically void Pennsylvania's laws, Delaware's laws, or any other state's laws. Its reasoning will influence challenges elsewhere in the circuit, but a ruling on New Jersey's statutes is not a ruling on other states' separate statutes.
The ruling also does not touch anything else in New Jersey's gun law framework. New Jersey's firearms purchaser identification card requirement for long guns still applies. The separate permit to purchase a handgun still applies. The background check process still applies. The one handgun a month rule still applies. New Jersey's sensitive places restrictions still apply. Every other layer of New Jersey's firearms regulatory framework is untouched by this ruling. A New Jersey resident purchasing an AR-15, whenever that becomes legal, still needs a valid FPIC, still passes a background check, and still completes all standard point-of-sale paperwork. The ruling removes the rifle type and magazine capacity restrictions. It removes nothing else. Now let me put this ruling in its historical context, because it did not arrive in isolation. 8 days before this ruling, on July 9, 2026, the Seventh Circuit decided Barnett versus Raoul and upheld Illinois' Protect Illinois Communities Act in a 2-to-1 decision. Chief Judge Michael Brennan dissented in that case, pointing out that the AR-15 is the best-selling rifle in America and that the banned magazines are standard capacity. 8 days later, the Third Circuit looked at the same constitutional question under the same Bruin framework and reached exactly the opposite conclusion. Within 9 days, 2 federal appeals courts produced directly contradictory answers to the same legal question. The Seventh Circuit said AR-15 bans do not violate the Second Amendment. The Third Circuit said they do. That is an irreconcilable circuit split, and it arrived after the Supreme Court had already granted cert in Viramontes versus Cook County and Grant versus Higgins on June 30, 2026, to decide the AR-15 question. The Supreme Court agreed to hear the AR-15 question when the circuit consensus was unanimous against gun owners. Every circuit that had addressed the issue had upheld assault weapons bans. That unanimous consensus no longer exists. The Third Circuit broke it. And the 192-page opinion it produced, written by a Biden appointee, applying Bruin faithfully, is now the most detailed judicial argument in existence for why AR-15 bans cannot survive Second Amendment scrutiny. That opinion will be in front of the Supreme Court when Viramontes is argued this fall. UCLA law professor Adam Winkler, a gun law scholar, stated on July 17th, "What this Third Circuit opinion shows is that there are very few gun laws that are safe from being struck down right now." Now let me walk you through the procedural timeline, because this is where the compliance picture gets complicated, and this is where most of the coverage has been imprecise. July 17th, the Third Circuit issues its 10-5 en banc ruling without a stay. No order pausing its effect. The ruling is issued. July 22nd through July 23rd. The New Jersey State Police Firearms Dealer Investigation Unit emails licensed dealers stating the ruling will be effective July 31st, 2026. Dealers begin preparing to resume sales of previously banned rifles and magazines. Then, the AG's office clarifies that July 31st is the deadline to seek rehearing, and that the actual effective date under Federal Rules of Appellate Procedure 40 and 41 would be approximately 7 days after that. The Third Circuit Clerk's Office told the plaintiff's attorney the mandate was expected to issue around August 10th. Compliance confusion spreads across the state. July 31st. New Jersey files a motion asking the Third Circuit to stay its mandate while the state prepares a petition asking the U.S. Supreme Court to review the case. Filing the motion itself temporarily pauses issuance of the mandate while the court considers the request. That is where we are now. The mandate has not issued. The stay motion is pending. New Jersey's argument for a stay is worth understanding precisely. The state argues it will suffer irreparable harm if gun stores begin selling AR-15s and standard capacity magazines before the Supreme Court acts. Throughout its motion, New Jersey invokes a 36-year-old status quo as justification for keeping the bans enforceable. The state says its Supreme Court cert petition is due October 15th. It wants the Third Circuit to keep the bans in force until the Supreme Court either denies that petition or, if the justices take the case, issues a final decision. To obtain a stay, New Jersey must satisfy 4 factors. It must show it is likely to succeed on the merits, that it will suffer irreparable harm without a stay, that the stay will not substantially harm the other parties, and that the stay is in the public interest. The likely to succeed on the merits prong is the complicated one, because the Supreme Court has already agreed to decide this exact question in Viramontes,
and the Third Circuit's own en banc majority just held that the government cannot meet its Bruin burden. Whether the Third Circuit grants a stay to a party it just ruled against 10-5 is the question now before the court. If the Third Circuit denies the stay, New Jersey will immediately petition Justice Alito, the circuit justice for the Third Circuit, to stay the mandate at the Supreme Court level pending the cert petition. Let me close with the compliance picture stated as clearly as I can state it. The Third Circuit ruled New Jersey's assault weapons ban and magazine ban unconstitutional. That ruling is real. But the mandate enforcing that ruling has not yet issued, and New Jersey's stay motion has temporarily paused the mandate's issuance while the court considers the request. That means the New Jersey statutes, NJSA 2C39-1W and 2C39-1Y, remain on the books and technically enforceable until the mandate issues and no stay prevents it. Any dealer who sells a previously banned rifle or a magazine holding more than 10 rounds before the mandate issues and the stay question is resolved faces potential exposure under state law that is still, right now, in effect. Do not act on this ruling as if the ban has been lifted. It has been ruled unconstitutional. It has not been lifted in practice. Not yet. There is a meaningful legal difference between those two things, and the consequences of confusing them are a state criminal prosecution. What you are watching for. The Third Circuit's ruling on the stay motion, which could come within days to weeks. If the stay is denied, watch immediately for a Supreme Court application to Justice Alito. If the stay is granted, the bans remain enforceable until the Supreme Court acts on New Jersey's cert petition in October, and potentially beyond if the court takes the case. And in the background, Viramonte's oral argument is expected this fall. Whatever the Supreme Court says in that case will settle the underlying constitutional question for every circuit, every state, and every gun owner in the country. The ban is dead on paper. The fight over whether that paper means anything before June 2027 is just beginning.